search persons, seize property, and arrest without warrant on mere suspicion of an offense. Such powers, without judicial oversight, create potential for abuse, intimidation, and unlawful interference in private premises, expanding surveillance powers far beyond what is necessary for public protection. Clauses, Chairperson, raising transparency and abuse risks. Clause 3 to 5, administrative control and committee composition. The bill establishes the National Public Security Command Center under the ministry responsible for internal security and vests all decision-making power in the National Public Security Command Center, composed exclusively of security and intelligence agencies. The absence of civilian representation, parliamentary reporting, or independent oversight mechanisms undermines transparency and accountability. Clause 11, prohibition of disclosure. Clause 11 criminalizes disclosure of information without committee consent, but fails to provide exceptions for public interest disclosures or whistleblower protection. This could deter exposure of illegal or unethical surveillance practices and shield misconduct from scrutiny. Clause 38 on immunity. This clause grants blanket immunity for actions done in good faith by officers and committee members. Without independent review mechanisms, this provision risks creating impunity for violations of privacy and misuse of surveillance data. Clause 42 on ministerial power to make regulations. The bill grants broad powers to the minister to regulate operational details, including acceptable or prohibited features of CCTV. Without defined consultation procedures or publication obligations, this could allow secretive regulations that bypass legislative accountability. Our fourth submission touches on the fragmentation of legal framework. The introduction of a standalone CCTV law duplicates and fragments existing privacy and cyber governance frameworks. Matters relating to the collection, storage, and processing of surveillance data are inherently data protection issues and should have been harmonized under the Data Protection Act of 2021, all integrated with the Cybersecurity and Cybercrimes Act of 2021. In international practice, CCTV and biometric surveillance are regulated as subsets of data protection regimes, not as independent security statutes. The fragmentation proposed by the National Assembly Bill 1 of 2025 weakens oversight, creates conflicting mandates, and may result in jurisdictional overlap between the Data Protection Commissioner and the Ministry of Home Affairs, thereby undermining consistency and enforcement. A comparative and international standards on CCTV laws. The European Union General Data Protection Regulation of 2016, enforceable since May 2018, is globally recognized as the gold standard for data privacy and accountability. It requires that there is lawful, fair, and transparent processing of personal data, purpose limitation and data minimization, explicit consent for data collection, storage limitation and accountability, and independent supervisory authorities to enforce compliance. CCTV surveillance under the GDPR must be justified by legitimate purpose, subject to impact assessments and limited to the minimum scope necessary. Citizens are entitled to access, correction, and deletion rights, and data controllers must maintain transparency in processing activities. The African Union Convention on Cybersecurity and Personal Data Protection, that is the Malabo Convention 2014, to which Zambia is signatory, mandates member states to enact laws ensuring that personal data is processed fairly, lawfully, and transparently with explicit consent and under independent supervision. We also have the SADC Model Law on Data Protection 2013. This framework recognizes that surveillance technologies must comply with proportionality, necessity, and data minimization principles. It underscores that state surveillance must be subject to judicial authorization and independent oversight. Together, these frameworks affirm that CCTV surveillance belongs within a comprehensive privacy and data protection regime, not a security-oriented statute devoid of human rights safeguards. Risks and implications. If enacted without reform, the ACA feels that the bill poses the following risks. 1. Erosion of civil liberties. Unchecked, surveillance can create a chilling effect on free speech, association, and assembly, all pillars of democratic governance. 2. Potential for political or personal abuse. Without transparency mechanisms, CCTV systems could be manipulated for political monitoring, selective targeting, or suppression of dissent, as noted by the President. And 3. Weak data protection. The absence of defined consent, retention limits, and redress mechanisms makes it impossible to guarantee compliance with Zambia's own Data Protection Act of 2021. And 4. Institutional overlap. The creation of a new command center duplicates the role of the Data Protection Commissioner and adds bureaucratic inefficiency. And lastly, public distrust. Citizens may view the surveillance system as a tool of state control rather than public safety, undermining cooperation and legitimacy. Our recommendations. Harmonization of legal frameworks. We recommend, Chair, that the CCTV regulation is integrated under the Data Protection Act 2021 or require statutory coordination with the Data Protection Commissioner. And 2, an establishment of an independent oversight body. Create a multi-stakeholder oversight board, including civil society, data protection experts, and Parliament to monitor implementation. Privacy impact assessments. We recommend a mandatory impact assessment before any public CCTV installation, including publication of scope, purpose, and data retention measures. 4, define retention and access protocols. Limit data storage to a fixed period, e.g. 30 days, unless warranted by a court order. Guarantee individuals the right to access or request deletion of their data. And 5, restrict ministerial powers where possible. Require that regulations affecting privacy, e.g. surveillance in sensitive locations, be subject to parliamentary scrutiny. 6, ensure accountability. Amend Clause 38 to replace blanket immunity with qualified immunity, subject to independent investigation. Whistleblower protection. Amend Clause 11 to exempt disclosures made in the public interest and to protect individuals exposing wrongdoing. And 8, adopt GDPR-aligned principles. Embed GDPR's principles of lawfulness, transparency, proportionality, and accountability as guiding standards for surveillance governance. And 9, mandatory public disclosure. Require the command center to publish annual reports detailing installations, data access requests, breaches, and any remedial actions taken. In conclusion, Chair, the Alliance for Community Action reiterates that while public security is a legitimate national objective, it must never come at the cost of constitutional freedoms and individual privacy. The Closed-Circuit Television Public Protection Bill 2025, in its current form, presents far-reaching implications for citizens' rights and democratic governance. The ACA recommends that the National Assembly defers passage of the bill pending comprehensive review and harmonization with the Data Protection Act of 2021 and international data protection standards such as the GDPR, the Malabo Convention, and the SADC Model Law on Data Protection. By adopting these standards, Zambia can build a surveillance governance framework that protects both public safety and personal privacy, upholding the constitutional principle that every citizen's dignity, liberty, and privacy must be protected against unwarranted institutions. unwarranted intrusion. I submit, Chair.
Thank you very much, Madam. And indeed, National Assembly, that's why you are here today, Madam. We want to ensure that a good job is done, and we have included you so that we listen to you, and we are happy with your submission before the law is passed. But just to take you back, Madam, to page 6, as a beginning, that is on para 4, not on recommendations, the other part, risks and implications. Para 4, the creation of a new command center duplicates the role of the Data Protection Commissioner and adds bureaucratic inefficiency. I want to get this maybe clearly with a question to you. This bill is a new bill falling under the command center, which has been created literally under Ministry of Home Affairs. That is bringing all the security agencies within the ministry, DEC, anti-corruption, Zambia Police, name it. They have created this to handle this very sensitive bill. What is your view? Are you still, or would you recommend that the same command center remains an organization that will handle this, or you would rather this bill falls direct under Zambia Police, or indeed any other institution under Ministry of Home Affairs? What do you think on this sitting, or the sitting of the bill? Your views?
Okay, thank you very much, Chair. So what we stated here is that the new command center, duplicates the Data Protection Commission. So what we feel is that the command center can stand on its own without falling under the Zambia Police Service, but with limitations of power, as stated in the recommendation, where we say we restrict the ministerial powers. Yeah, so it can stand on its own.
So you recommend the bill falls under the command center?
Yes.
Okay. Honorable members, are there any questions arising from the submission? Honorable Botos.
Chair, thank you very much. There's been submission from other organizations that the data collected or the footage must be stored only for a period of 30 days. However, this committee, the witness before this committee today submits that yes, it can be 30 days. However, it might be kept longer due to ongoing investigations. But they are saying there is no proper definition for ongoing investigations. So my understanding, Chair, I just wanted them to give more clarity. Are you saying it is still okay for this footage to be kept longer as long as investigations are going on, but there should be a clear definition of what ongoing investigations is? Because looking at our cases, Chair, mostly, they take longer than 30 days, and that evidence might be needed.
Indeed.
Yeah, so I clearly wanted to get your submission that should the owners of this bill come out very clear to tell us what ongoing investigations is. Is that your submission? Thank you, Chair.
Please, Madam, attend to that.
Thank you, Chair. Indeed, Honorable, yes, we do submit that the data collected and retained should be at least to a minimum of 30 days, but also taking into consideration the time it takes for our court proceedings or cases to be handled. No wonder we even put a qualifier alongside the 30 days, that they can be kept even longer unless warranted by a court order. However, emphasis is still on what do they mean, what do the orders of the bill mean when they say investigation, ongoing investigation. So that should be clearly defined in the bill.
Okay. Are there any other observations, colleagues? Minister of Justice, any clarifications you would like to make?
No, we have no comments, Honorable Chair.
Okay. But I hope you have taken note of the submissions. Please.
We have duly taken note of the submissions, Honorable Chair. Thank you.
Thank you very much. And therefore, Alliance for Community Action, I think it remains my humble duty this morning to once again thank you most sincerely for coming through. Please do not, your Parliament, your National Assembly cannot be able to operate in a vacuum. We require stakeholders such as yourselves so that we can be able to make laws that will stand the test of time for the betterment of our country. It's for this that on behalf of Madam Speaker, I sincerely thank you for your appearance, and we look forward for you coming again. And I think we note since your formation, you have always been available to Parliament, which is how it should be. So together with your parliamentarians, we can make laws that our children or those coming after us will be able to say, well, I think we had parents who left a good foundation for our country. So we once again thank you most sincerely, even as we withdraw that little minute, Madam, that we conferred on your team. You remember, remain with a greater immunity that all of us enjoy out there. So please have a pleasant morning, and thank you sincerely. Thank you, Madam.
Thank you so much, Chair. And we send greetings also from the Alliance for Community Action, our
Great.
Executive Director, Laura Miti. Thank you.
By the way, how big is your organization? Just Lusaka based, or we are at provincial centers already?
So we operate project based. Our offices remain in Lusaka, but we do have projects across different provinces, Mukoshi, Central Province, Luapula, with limited to project sites.
10 provinces?
No, we are yet to go to Northern and Western Province.
Okay.
Yes.
Thank you.
Thank you, Chair.
No? Good day, Madam.
Parliament is open to members of the general public who may wish to undertake familiarization tours of Parliament buildings, either in groups or as individuals, or to attend sittings of the House or parliamentary committees. All those wishing to visit Parliament can either write to the Clerk of the National Assembly of Zambia or simply come to Parliament buildings. Upon arrival at Parliament buildings, visitors are required to identify themselves. A passport or national registration card is required for identification purposes. All visitors to parliamentary premises are required to wear smart attire, either office or casual wear. Before gaining access to the galleries, all visitors are oriented and issued with passes by the Security Department at the Media and Visitors Center. Those whom permission is granted to sit in the galleries will be ushered to the appropriate galleries by protocol officers. Furthermore, visitors are not allowed to take with them into the galleries such articles as walking sticks, umbrellas, briefcases or parcels of any type, newspapers, magazines or cell phones. All such articles must be deposited at the reception desk. Visitors to the galleries are given copies of the order paper, which shows the order in which the business of that particular day would be taken. You can follow all parliamentary sessions and committee sittings on GoTV Channel 28, Topstar Channel 5, DSTV Channel 272, Parliament Radio, or like the National Assembly of Zambia Facebook page.
Stay entertained anytime, anywhere with DSTV Stream. First, download the DSTV Stream app from your app store. Sign up and create your multi-choice ID with your email, phone number, and password. Link your DSTV account to your customer number. Choose SMS or email verification. Confirm with the OTP sent to you. Download the DSTV Stream app now and never miss a moment.
Serve goals, thrills, and high fives alongside your fries with DSTV for Business, and turn your pub, club, or restaurant into the ultimate entertainment hub with world-class live sport, breaking news, music, and so much more. Plus, with ExtraView, you can also show multiple live events at the same time. Our DSTV Play packages are tailored to meet your needs and budget. Contact us today to serve up the ultimate entertainment experience with DSTV for Business.